You are listening to the Justice in Heels podcast with me, your host, Danielle Hayward. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us.
Hello and welcome to another episode of the Justice in Heels podcast. Today we have one of our regular guests on the podcast. Please help me welcome Jennifer Scholtz. Jennifer, welcome to the podcast.
Thank you so much, Danielle. And it's really nice to be here again today, talking about a different topic, which is our Rule 43s and Rule 58 applications.
So, for the listeners who may not know you or who did not listen to the previous podcast that you were a guest in, can you just tell us again, who are you? What are you passionate about?
Sure. So I have run a family law practice for the last 18 years, specializing only in family law. So I often find that as a practitioner, if you specialize, it appeals to people a lot if they know that they're coming to a very experienced family law attorney. And also a big part of my practice is lecturing. So I train the candidate attorneys or candidate legal practitioners that they're called now. I train them in anticipation of their admission examinations. So I train a lot in the lead program and then at a couple of the larger firms as well. So lecturing is also my passion, and particularly, lecturing the family law syllabus. So that's about it. I think that a big part of my practice, which I should mention in terms of current law, is mediation. So we would invite the couple to come along to our offices together, and it creates a good atmosphere for the couple. And they come in independent, and then we negotiate their divorce settlement agreement, which makes it a lot quicker, the divorce, and a lot more affordable. And in terms of our current law, it's compulsory to attempt mediation before you go to litigation. So for all matters, family law included. So that I do a lot of, and for the best interest of the children and the best interest of the parents, the mediation is a good option offered to people.
Fantastic. So let's start with today's topic, which you already mentioned is Rule 43 or Rule 58 maintenance applications. So can you firstly just tell us what does a Rule 43 or a Rule 58 application entail?
Sure. So the Rule 43 application, that's in the High Court, and then the Rule 58 application, it's the same application, but it's conducted in the magistrate's court. So often the magistrate's court is quite a bit cheaper than going to the High Court. So you can do either. The Rule 43 application, the purpose of it is to give the party who's struggling for maintenance or whatever the case may be, to give that party a relatively quick, so a speedy and affordable option. So that's the purpose of it, and to keep your papers short and to the point, and not to, sort of air your dirty laundry in public. So just to stick with what you're asking for, and the financials and that kind of thing. So the Rule 43 is, we call it a pendente lite, that's the Latin word, which means that it's pending the outcome of the divorce action. So if you've filed for divorce, and the defendant, say it might be the husband, the defendant opposes the divorce, and perhaps his attorney or him are dragging the case along. So they're bringing applications, they're bringing actions against the woman. I'm going to say the woman in this case, but it is gender neutral. Okay, so we also cater now for house, we call them house husbands. And they are husbands who've, always been looking after the kids. So it is gender neutral. So you would bring it if the proceedings were protracted, and you were usually when you're struggling for maintenance. So what the Rule 43 covers then is when the order's made by the judge or the magistrate, then that order stays in place until the divorce is finalized. So it gives a good interim measure for that woman.
Amazing.
Okay,
So
then.
perhaps, sorry.
Sorry, do you want me to continue with what you can ask for in a Rule
Please,
43
yes.
application?
Yes, that was going to be my
Okay, so
next question.
I preempted you. So the things you can ask for in your Rule 43 or your Rule 58, the one is interim care or contact with a child. So very often a father would launch the Rule 43 application where he's not getting rights to his child. He's not getting regular contact, and he's battling to see his child. And he's battling with, joint decision making, and possibly the wife um, sort of, sorry, I've lost my wording.
Keep the
Possibly the
children
wife
from him.
restricting. Yes, to keep the children from him. So that's one of the ways you can bring it. And then a big part of the Rule 43, which we mainly use Rule 43s for, is for maintenance for the children, and in some cases, maintenance for the wife. So, and I think you've had some other podcasts dealing with maintenance and that kind of thing. Um, and then another thing it can help with is it gives an interim contribution towards the costs of the divorce, because we find often the woman is in a not a good financial position compared to the husband. And if the husband is forcing her to litigate, then we need to tell the court that, give them full details of, what we're claiming, what is our costs that we want to claim. And we would normally um, attach what we call a bill of costs, and then that bill of costs will itemize for the judge or the magistrate everything that we want to claim. And so it's in detail. That's how you should do your Rule 43 or your Rule 58. And then the last thing it covers is sort of other, the topic of other. So what they can sometimes do, the courts, is give the woman further relief. So if, for example, she's had to vacate the home because of domestic violence, for example, with the children, and maybe she's had to be forced to live with her parents, or to live with friends or something like that, so she's not in a good position. The court is allowed to order that her movables, so her property, gets given to her by the husband, or to order, if she was possibly driving the family car and it's been taken away from her, they can also order that car, for example, be returned to her so she can use it for the benefit of the minor children. So those are the four things, and I'll tell you just now sort of how you go about it. The one thing with your Rule 43 or your Rule 58 is there has to be a divorce pending. So you couldn't use it if, you had your client was an unwed father or something like that. Or your client was, an unmarried woman who needed maintenance. then you would have to go the route of the maintenance court to get these kinds of things in place.
Fantastic. I'm very glad that you actually mentioned that because I know there's a lot of people who wonder about that. Like if I was not married to this person, but we maybe had children together and now we split and they are perhaps withholding contact with the children, or maybe they are not paying the amounts that they used to pay. Can I use this Rule 43? So yeah, so before we go into the process of this Rule 43 or this Rule 58, can you maybe just tell us, do you need an attorney to run this process? And if you need an attorney, why you can't do it on your own?
Okay, perfect. So in all cases these days before the courts, you are entitled to be unrepresented. We find that when people are unrepresented, they do feel intimidated and they sometimes struggle to get information from the court staff, unfortunately. So you can definitely do it on your own, but it's going to be in the magistrate's court. It's going to be time consuming for you. You'll have to sit with the clerk of the court and yeah, and give the clerk of the court all the information, have it served on the husband. So it is more difficult to do the Rule 43 on your own. So we would normally recommend to be represented, especially if it's in the High Court. And the only difficulty with using an attorney is obviously the cost. The Rule 43, it's supposed to be a sort of an application that's not costly to someone who's claiming maintenance. But unfortunately, if you use an attorney, it is going to be costly. There's affidavits to be drafted. In High Court, we would use an advocate. And in order to make sure your client's case is watertight, unfortunately does cost money, which doesn't really make sense because the wife is needing maintenance, but now she's got to pay money to an attorney to try and get that maintenance. And in previous years, in my practice, we used to the Rule 43 application used to be a very simple application. So it was short, it was to the point. We would do, maybe 15 pages for the judge, just setting out what we needed in terms of maintenance. And over the years, the Rule 43 applications have become much longer and more detailed. So we would find, recently we've been served with a Rule 43 application, and it's 189 pages long. And it's also riddled with, things like the fighting between the parties, the fight over the children. So it's very detailed and it's got a lot of annexes and attachments to it, which is not really necessary. The judge doesn't really want to know that what's going on with them fighting and arguing and that, unless it affects the kids. So unfortunately, what's happened, you would get, say, papers that were 189 pages, and then you would have to reply, your client would have to reply to all those allegations in those pages. So that might be another 100 pages. So by the time the judge sits with it, it's in excess of 300 pages. So it's, and I'm not sure over the years why it's become like this, but it's not really, for the purpose of, what the Rule 43 entails. So that is a problem with Rule 43 applications.
Definitely. And I think it's also not even speaking about like how time consuming it is. I think it's also much more emotionally taxing if you do not have an attorney to help you through that entire process. Yeah. So Can you maybe just tell us
That's
what is the,
correct.
yeah. So what is the first step that you would take when you want to institute Rule 43 proceedings, and how does the process go from there?
Sure. So the first step that you would normally take is you would normally have a summons in place. So because remember the Rule 43 application, you can only use it if there's a summons already in place. So what you would do is do the summons process. You can, what a lot of people do is they have the Rule 43 application served at the same time as the summons, especially where they're really struggling financially. They do it quickly. And there has been case law in which they do it the Rule 43 application prior to the issuing of the summons, but that would be in exceptional circumstances where it was something more urgent. So if the client was on the streets or they didn't have a place to live with the children or something. So what you would do then is you would gather your documents, which I'm going to talk to you about just now. You would start with drafting the founding affidavit. So that's the first affidavit to the application. And then that would be signed by your client, if we're representing our client. That gets signed by the client, and then in front of it we put what we call a notice of motion. And the notice of motion sets out, what are your prayers, what relief are you seeking. And the difference would be that the other side, the respondent, only has 10 days to respond. So, and they respond with an answering affidavit to the main affidavit. So they take each allegation in the founding affidavit, and then they respond to it and tell the court their side of the story, basically. And you're not allowed another opportunity as the applicant to put in a further affidavit. So it's what goes to the judge is basically the founding affidavit and the answering affidavit. In other normal sort of applications in court, there's longer time periods. So there's like 15 days to answer, and then the applicant has another opportunity so they can reply to that affidavit. So the Rule 43 is then shortened. So there's the 10-day period, and then after the 10 days have expired and you've got the answering affidavit from the respondent, then we can apply to court to have the matter set down. And what is quite exciting about the courts now is they've established in the High Court, they've established a family court within the High Court. So the family court is hearing all kinds of family law matters, including Rule 43 applications. The time periods are a lot shorter if you take a matter to the family court. And the experience of the judges is family law orientated. So you would get, judges who've been in family law practices and that for many, many years. So that's a very positive thing that's happened. So that's making the Rule 43s go a little bit faster as well. And then you would obviously have your hearing with the judge. But maybe before that, I should talk about, the documents that you need and that kind of thing. So you can gather your evidence. All right, so a case I just wanted to mention, which I was involved in, it was a few years ago, so it was around about 2018. It was called E versus E, if anybody wants to take a look at it. It was a reported judgment, which is also always nice for an attorney. And basically what the judges said there is we need something on oath, that both parties, they sign on oath as to what their assets and liabilities, their income, what the expenses are of each of the households. So that case led to what we call the financial disclosure form. And a lot of attorneys, when they hear that phrase, they're like, no, we've got to do a financial disclosure form. It's a very long form that was introduced, and you could get hold of it if you want to, obviously, on the Department of Justice website, especially if you're unrepresented. So the purpose of the financial disclosure form is to make sure that that both parties are honest. So when it gets to the court, they've given all their documents, they've itemized everything. I'll take you through now what needs to go into it. And hopefully, because they're signing under oath, hopefully they would be telling the truth. So what it basically does away with like in E versus E, we felt that the husband was hiding assets. So the judge was saying it's very hard to tell if the husband's hiding assets because we actually don't know what his assets are. So so that was a very interesting case. And so it led to the financial disclosure form, which the financial disclosure form needs to be delivered with your papers. Okay, so before the time comes for the hearing, and it's a very long form, so it's about 28 pages, and it's very detailed. So they basically ask. I'll just run you through what they ask for. I'm just going to refer to it in my notes because it's so long. So they would first look at, have the couple got any immovable property? So houses, land, flats, that kind of thing. And then you would you would have to put it all down there. You'd have to have valuations on the properties and that kind of thing. And then importantly is you need to disclose your bank accounts. So it's the last 6 months of bank statements for all your bank accounts. And that's something that's usually very difficult to get hold of in divorces. So it's quite nice that you can get hold of it here. Investments, so they look at pension funds, policies, life policies, that kind of thing. Then they also look at liabilities. So what do you owe? Which unfortunately a lot of people have, big liabilities and debts. Then they would see if you run your own business, you would obviously have to give financials and audits and all that kind of thing. And then they would look at if you get any income from any other type of employment that you might have. So do you earn income in cash, for example? Do you get commission? Do you get bonuses? They would look at all those kinds of things as well. And then about 5 pages of it is an expense sheet. So in that expense sheet, it's long. In that expense sheet, you would have to put down all the expenses of the household. And you don't, in the Rule 43, you don't have to have receipts and slips for, groceries and all that kind of thing. Because that would often can be seen from the bank statements. So you would fill in, you'd look at the number of people in the house, and you divide it up between in this case, the mom and the children, and then get to a figure as to what you need. So how much do you need? If you haven't worked for the last 15 years as a spouse, you can then ask for, you put in there your spousal maintenance as well that you want. You can put in, we generally try to, to not go into much detail, but you can put in if there's been any changes in the household, if there's been bad behavior by one of the spouses, drug abuse, alcohol abuse. Is any of your employment going to change in the near future? Have you had to take employment at a lower salary? So you can put all those things in, but I do find, especially when it comes to the bad behavior, I do find that it throws a spanner in the works, because then the other party receives it, and it doesn't look good if there's been abuse and that kind of thing. And the judge doesn't decide the case on, on misconduct on the part of the parties. But you can put that in. So, I mean, and then you literally attach everything, the last 6 months bank statements, the property, the investments. So it does turn out to be a very large document. Okay, and it takes time to prepare. A lot of clients are unable to do it themselves because it's quite complicated. So we would then assist them, in getting it ready and explaining to them how it works and all that kind of thing. So hopefully the financial disclosure form has solved some of the problems. And the judges rely heavily on the financial disclosure form. So that's just a little bit about the documents that you need to produce before the hearing of the matter.
Fantastic. So before we continue, I really need to compliment you. You are really good at taking this very long process and making it sound so simple and explaining it so like in lay terms. You are really great with that.
Thanks so much, Danielle. Yes, I try to, it's important with clients now, I think, to, be simple when you deal with them, because they don't know the fancy legal terms. And so it assists my clients to speak to them, on a lay person level. So yes, so I do try and do that. Thank you for the compliments.
So, can you maybe discuss any notable cases where this, like a Rule 43 application, impacted the parties significantly? I know you now mentioned the E versus E case with the financial disclosure form, but are there any other cases that you can maybe tell us about? It was quite interesting.
So, in terms of case law, there's a lot of case law about Rule 43s. And the problem with the case law is that every case is decided on the merits. So you might find, there's a couple that's affluent, so they're a wealthy couple, and, their expenses are a lot higher than someone who, was from a maybe middle class or low class or something like that. So the case law, there's quite a lot, and I think since we've had the family court, there've been quite a few cases, but they've been decided in very different ways. So, for example, the contribution towards the legal costs. There've been some cases now where if the husband is deliberately forcing the matter to go to trial, where the court has ordered a very large contribution towards the client's costs. So that could be, there's one recently where they awarded 300,000 rand to the wife to litigate. But that's where it's a wealthy situation, and the husband can afford it according to the financial disclosure form, and he's forcing our client to litigate. And I mean, you should always try. It's a little bit off the topic, but you should always try as a lawyer before you even institute your action or launch your application. You should try to see if you can't mediate first, instead of coming to court and, not having tried to resolve things. I mean, there are cases where, the husband and wife are fighting and they can't mediate. But I think it's a good idea beforehand to try that. And also for the attorney to sorry, I've lost my train of thought. I've been lecturing for 4 hours, so I'm just losing my train of thought. The attorney can also do a letter of demand, so where they calculate all the expenses and put it into a letter to say this is what the wife needs, this is what the kids need. And then if the husband's attorney doesn't respond, or they say we're not prepared to pay that amount of maintenance, then you could take it forward. So a lot of the cases where we get big contribution towards costs awarded are those ones where one of the parties is fighting and the matter just can't be resolved. And so those awards have been large. There's also been some cases where the wife has she's just increased her expenses, into huge amounts that are unreasonable. So there are cases recently where the court has said to the wife, your expenses are unreasonable. So and they haven't granted a large maintenance order. So there's been a lot. There've been cases about special needs children, where the judge is very sympathetic to if it's the mom that's been bringing up the special needs child. So special needs children, the judges would be sympathetic, and they would normally order more maintenance because, the child maybe is homeschooled and can't go to a normal school. They have carers who they need to come in and help, and tutors. So that's a different scenario, but that's also been adjudicated on. So there's so many, and they're all different. Every case, as you know, Danielle, every case is different and depends on the expenses of that household. Okay, so that's
Fascinating.
more or less to do with case law.
Yeah, thank you for that. That was like quite interesting. So how are these Rule 43 or Rule 58 orders usually enforced?
So it's turned into a proper court order. So if the husband doesn't pay, and we do get cases where we have a court order and the other party feels like they're above the law, so they think, well, they're just not going to pay. And it's a common problem in our courts, is enforcement of maintenance orders. So what you would have to do if there is a default by the other party, there's a couple of options. So the one option is to place that party in contempt of court. So that's an application that you bring to the court to say he hasn't complied, and this is what he's owing, and you must place him in contempt of court, which can include a time spent in jail. So that the judges can make that order. So you can do that, or what you can do is what we call a writ of execution. Sounds terrible, but the writ of execution is where you take what's outstanding to you. You tell the registrar of the court, and he issues the writ, and the sheriff can then go and attach furniture, attach a bank account, attach if there's shares in a company. That then gets attached in lieu of the debt. And then all that furniture and that gets sold and gets put towards what's outstanding. But it is a long process, and it's, it's quite complicated. So one would hope that you didn't have to go that route. And you hope that the person wouldn't default because it is a court order.
Yeah. So
Still do.
So, I mean, like you mentioned that Rule 58 and Rule 43 orders are for interim maintenance. So, in saying that,
Yes.
is it possible to actually modify a Rule 43 or not? And if it is
Yes.
modifiable, in which circumstances?
Okay, so that's a very good question because Rule 43s can be modified, but it's very difficult to modify them. So you can't take them on appeal. So what you would have to do is you bring what we call a Rule 43 in brackets 6. And the Rule 43.6 is where you apply to have it modified and you show circumstances have changed. So it's very difficult because you have to tell the court that what were you earning at the date of the Rule 43 order, and then what are you earning now? Because it's usually the men that come forward and say that they don't have money, unfortunately. So yes, so you would present that to the judge. Changing circumstances is very hard to prove. Um, so the types of things that would be a change in circumstance is if say the husband got retrenched and he couldn't find another job, or he got sick and he couldn't and he couldn't work, for argument's sake. Or in these days and times, maybe he had a good business and the business is now liquidated or something like that. So those would be good reasons for a change in circumstances. But you can't just go there with a Rule 43.6 and say, well, I was earning that 2 months ago, and I'm still earning the same, but I want to change the order. So you have to have your reasons very well. They don't often grant a Rule 43.6 in the courts. It's very unusual. So it's a
Okay.
difficult thing to do.
So I know you mentioned the mediation and all matters now need to be mediated, but do you see any or foresee any potential changes or reforms to the Rule 43 in the future?
Look, I think that it's been formalized with the financial disclosure form. So that seems to be working well. So at this point in time, I don't think there would be any changes, but I think that with the financial disclosure form and with our family court now, with experienced judges, I think that that's helping. It's going a long way towards helping with Rule 43s. It's making them quicker, and obviously with experienced people making decisions on them.
Fantastic. So, Jennifer, I want to thank you for taking the time to appear on the podcast again. We know you are really busy. So yeah, thank you so much. Where can our listeners reach you?
So thanks, Danielle. I've really enjoyed the my second podcast with you. It's lots of fun, and yeah, it's a very nice thing to do. So thank you for having me on the podcast. So the best place to reach us is if you go to the website, which is www.jenniferscholtz.co.za. And then you'll find my details, our email address, phone numbers, what our practice is all about. And we offer very personal service. So it's a small firm, a small but busy firm. And because we specialize in family law, customers get good service from us, and they like someone who's only doing family law and not trying to, to do all kinds of different law in one practice. So yeah, so you can reach me on the website, and I'd love to, if you contact me, if you have problems, Rule 43s, unmarried fathers, anything like that, we can assist you with.
Thank you for listening to this episode of the Justice in Heels podcast. If you enjoyed this episode, feel free to share it with your friends on social media and tag us. As this podcast has a legal element, just a quick disclaimer that all views expressed in this podcast are not necessarily the views of the firms, companies, or brands that we are associated with. Until next time, goodbye.